This is Immigration Attorney Jeff Jung, and I'd like to speak to you today about an important benefit whereby people can get a green card through a U.S. spouse even if the relationship has turned abusive. Most times when someone seeks a green card through their U.S. citizen or permanent resident spouse, they do so without any problems. However, sometimes the relationships can turn abusive, and when that happens, the applicant can feel trapped in the relationship when the petitioner refuses to cooperate or threatens to have the applicant deported. Because of this, Congress passed a law in 1994 allowing applicants to continue with their green card applications even without the cooperation of an abusive spouse. So today we'll look at the advantages of such an application and the procedures for it. The first requirement is that the applicant must be married to a U.S. citizen or a lawful permanent resident. It's also acceptable if the applicant was married to such a person, but that marriage ended within the last 2 years, either by death or by a divorce that was in connection with that abuse. Even if the marriage was void because of bigamy, meaning that the spouse was married already to another person, the applicant can still qualify as long as he or she wasn't aware of this. A second requirement is that the applicant must have at some time resided in the United States with that U.S. abusive spouse. It doesn't matter for how long, and it's not necessary that they still be residing with the U.S. spouse. A third requirement is, however, that the applicant still reside in the United States with or without that spouse. Alternatively, it's acceptable if the applicant experienced abuse in the United States or by a spouse who was working for the U.S. government or the military anywhere in the world. Yet another requirement is that the applicant be found of good moral character, which generally means upstanding behavior without a criminal history, an asset to the community. Problems can be caused by such things as certain crimes, drug use, failure to pay child support or file income taxes, causing harm to people. Another requirement is that the marriage must have been entered into in good faith, meaning that it was not done just to obtain an immigration benefit. So there will need to be proof that the couple did live together as a married couple and sharing assets and rights and responsibilities. And finally, and most importantly, the requirement is that the applicant be the victim or else the parent of a child who was the victim of the spouse's physical abuse. It can also be extreme cruelty, not including physical abuse. That can take the form of things such as harassing, destructive behavior, threats to harm the person, threats to have the person deported, manipulative, controlling behavior, stalking. Any of those perpetrated by the U.S. spouse or parent during the marriage or the intended marriage will help qualify. So it's necessary to get proof of all of these things, and the advantages of doing a VAWA application that make all that proof worth the while is that the applicant is free to remarry as long as he or she waits until after the petition is approved. Getting married before the petition is approved would void the petition. The applicant does not need to continue living with that petitioner or secure his or her cooperation in any way. The abusing spouse does not have to go to the interview, does not have to provide support, does not have to sign anything or provide papers of any kind. Unlike with most green card applicants, it doesn't matter if the applicant never entered the U.S. lawfully. And it also isn't necessary for the applicant to provide a sponsor that can show financial support for the applicant. There are even special waivers for certain crimes and misrepresentations that wouldn't be available to normal applicants, but that can possibly help an applicant who has certain criminal incidents in their past. Now, the most difficult thing to prove is often the abuse itself, and some things that you can use for this purpose would include police reports, transcripts of emergency calls, court orders including restraining orders, records from hospitals or doctors about injuries or injuries that were sustained long ago that still have signs like scars, any records of counselors, therapists, psychiatrists, shelters. Also useful are declarations signed under penalty of perjury by yourself, where you tell your story in detail, or by witnesses, friends and family and associates who either know personally of the abuse or have seen the injuries. And records of phone calls and other communications from the abusing spouse, texts, emails, perhaps with threats or apologies even, letters, and photos of the injuries themselves, all can be useful in meeting this burden of proof. If your VAWA petition is approved, meaning that USCIS believes that you've established the relationship, the good moral character, the abuse, and all the other requirements, you will then be able at some point to apply for your green card. If your abuser was a US citizen, you'll be able to apply for that green card right away. If your abuser was only a permanent resident, you will have to wait for your priority date to become current. While you wait, you will be considered to be remaining lawfully in the US and can apply for work authorization. The priority date that we're talking about is the date that your VAWA petition was approved. Or if your abuser previously filed an I-130 family petition for you, you're allowed to use that earlier date. There's then a waiting period as USCIS works its way through the dates, and you wait for your date to become current. The VAWA application is even available to people who have been ordered deported or are in the process of their deportation hearings. Being in removal proceedings does not prevent you from applying. You can ask the judge for time to have your petition approved, and then, if it is approved, to close your case so that you can apply for your green card. You can even get your case reopened if you already received a deportation order. There's a special law that gives the judge the power, if they're willing, to reopen a case so that you can apply for this benefit. If you think that you might benefit from these laws, be sure to consult with an experienced, licensed attorney as soon as possible.